Hello, good afternoon, and thank you everybody for joining us live for our latest anti-money laundering webinar. For those of you who haven't met me yet, my name is Lex Jones, and I am Director of AML here at the SRA. In this session, we're going to be lifting the lid on anti-money laundering enforcement. You're going to hear from our investigations team about recent trends and findings. We're also going to talk through areas of law where we see breaches and provide guidance on the controls we think you should be putting in place. Today, I'm joined by two of my amazing investigations team. I have Tracy Bourne, Investigations Manager, and Sarah Jones, Senior Investigations Officer. Now, the way this session is going to work is that we'll start with some updates from Tracy and Sarah. They'll take you through some case studies, some common findings, etc. And then we will open up to you, our audience, for a live Q&A session. If you want to submit a question, and I suspect our frequent flyers probably remember how this works, but for anyone new to us, if you want to submit a question, you should be able to see a link underneath this video. You simply type your question in there. You can add your name or you can remain completely anonymous. It's up to you. Please, 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 though, don't be shy. Do start submitting questions just as they come to you during the session, and I will then start putting them to the panel as soon as the Q&A opens. The only reason I might not ask your particular question is if we've either already covered it, because it doesn't help anyone to just keep repeating the same content. If we've run out of time, in which case we might need to repeat this webinar perhaps a little bit later in the year, or if your enthusiasm for typing out your question has overtaken your typing skills and I am unable to make head nor tail of what it is you were trying to ask, in which case, of course, please do just resubmit your question and we will ask that. I will just remind you all, of course, that we cannot answer specific circumstantial questions or questions about individuals, so please do keep them general. But that is definitely enough from me. I'm going to hand you over to my colleagues, Tracy and Sarah. Ladies.
Thank you, Lex. So good afternoon, everybody. The aims of this webinar today are to share a little bit of background about the AML team, to talk about the general trends seen in enforcement action, to provide some case studies, and that's going to be my colleague Sarah. We also want to talk about some of the common issues that lead to enforcement action being taken and give you some tips and hints for how to perfect your AML control environment. Okay, if we have a look at the background of the AML team. So we were set up as a directorate in 2019, and there are now 35 team members who work across 3 different teams. So we've got our own dedicated policy team, we've got the AML proactive supervision team, and we've got the AML investigations team. So Sarah and I are part of the investigations team. So the majority of our work, probably around 75% of it, is actually referred on from the proactive supervision team. So the rest of it comes from the police, from the National Crime Agency, also from firms and individuals within the public. So there is a few bits and pieces more. You may have read in the legal press that actually enforcement activity increased probably by around 100% in the financial year 2023-2024. That's also been highlighted on LinkedIn, and you can read about it in our annual report. What we wanted to say was that this isn't because of a significant increase in lack of compliance across law firms. In fact, it's probably the opposite. We're seeing overall an improvement in AML control. It's because of an increase in on-site inspections and also desk-based reviews by the proactive supervision team. This in turn has led to an increase in referrals to the investigations team. Obviously, our staffing numbers have increased. Also internally, I think it's worth mentioning that there's been improvements to both process and our systems internally at the SRA. And this is with the idea of making this a little bit slicker and to try and improve the timelines for dealing with AML matters and also investigations overall. So we're due to report again soon. We are anticipating that the amount of enforcement action will increase again in the next financial year, and you'll be able to read about that probably in about 4 or 5 months' time. Finally, just to touch upon the area of conveyancing, you'll see it on the slide there. As per the sectoral risk assessment, we still consider both commercial and residential conveyance as the greatest risk for money laundering activity. So what this means in effect is if we see firms that actually undertake a large proportion of conveyancing work, we will be looking at things in a little bit more detail to try and understand the risks around that. Okay, so if we move to the next slide, we're going to look at some of the outcomes. So if you have a matter that's referred to the investigations team, these are the sorts of things that we can potentially do. So closure with no further action. This actually happens in around 70% of the matters that we look at, which is quite a large proportion. And probably to give a bit more information around that, obviously a lot of the work that we have referred in is for a particular reason. When we get hold of it in the investigations team, our job is to dig a little bit deeper and to request information from firms so that we can understand exactly what's been going on. So when we have a look and when we are able to satisfy ourselves that the AML control environment is okay, then we will close the matter. Okay, the next type of action we can take is a closure with guidance or a letter of advice. Very, very similar. The letter of advice, there were 27 of those in the financial year 23-24. So with those, it's usually a minor breach, and we're giving a little bit of advice for perhaps improvements that can be made, and they are recognised under our RDPRs. The next is a warning. There were 2 of those in that financial year. And then we move on to financial penalties. So that can be via a notice or via a regulatory settlement agreement. So the notice obviously goes off to our adjudication team. The regulatory settlement agreement is something that is agreed between the SRA and the firm or individual. There were actually 35 fines via notice in the year 23-24 and 9 via regulatory settlement agreement. Although I think it's probably worth saying that regulatory settlement agreements are something that we're trying to promote at the moment. And again, in line with the improvements to our systems and procedures internally, we're trying to speed up our process because we understand how frustrating it is for practitioners to be sitting there while we're investigating. So the aim is to obviously get the customer service as best we can. Conditions on firms' authorisation or practicing certificates, they are quite rare. They're generally in circumstances where perhaps the firm is doing in-scope work, but they've either got no AML policies whatsoever, or their AML policies are a little bit sketchy. The only time that we would consider putting on a condition is perhaps where the firm is resistant to actually changing their AML policy or making them compliant. So the condition would be to stop them doing in-scope work, and that happened on one occasion in 23-24. And the final option is to refer to the Solicitors Disciplinary Tribunal. That is quite unusual because our fining powers obviously increased to 25,000. So the only circumstances that we would make a referral are generally when the fine is above that amount, or alternatively, where there's a suggestion or an allegation of integrity or dishonesty on the part of an individual. So very unusual, and we're expecting in the next year to see, again, a limited number of referrals to the SDT. So the next slide will show the level of our fines. Again, this is lifted from the year 23-24. You'll be able to see that in the slide, the actual fining band, £10,000 to £20,000, is by far our largest sort of number at 41%. So when we look at fines, obviously it's dictated by our enforcement strategy and also our fining guidance. So when we get to the end of an investigation, we're taking account of the risk. So we're having a look at how much in-scope work you do. We're looking at the areas of your work. We're looking at your turnover, and we're having a look to see if there's any harm been done or any money's been lost, and that will dictate to us the band that the fine should fall into. Sarah in a moment is going to talk about some case studies, but there is plenty of I suppose work available or evidence on our SRA website that talks about the fines that we've actually done in the past. So everything's published on there, so you can have a look. Okay, so I'm going to hand over to Sarah now to talk about the case studies.
Thank you, Tracy. Good afternoon, everybody. So in the first case study, we're looking at a firm who was issued with a fine of over £46,000. This is a licensed body, meaning we are granted higher fining powers than that for recognised bodies. Our proactive supervision team carried out an inspection, which resulted in a referral to us for investigation. The breaches we identified were serious and were stretched among several areas of the regulations. The firm was of significant size and nature to require an independent audit, but this wasn't done until a couple of years ago, and the matter concluded by way of a regulatory settlement agreement. In this matter, our proactive supervision team carried out a desk-based review at a registered sole practice. The breaches here are an example of where AML compliance has slipped at file level, and it did result in a financial penalty of over £2,000. Although the breaches were considered serious, we did give the individual mitigation because the firm had adequate PCPs in place, along with an appropriate firm-wide risk assessment. However, there was a disconnect between the firm's processes and what was being carried out on files. In this matter, our proactive supervision team carried out an inspection at this long-established medium-sized firm. It had breached the previous regulations as well as the current ones. When it started risk assessing clients and matters a couple of years ago, it wasn't documenting them, so it couldn't demonstrate to us as the supervisor that the extent of the measures it had taken to satisfy its requirements were appropriate. A regulatory settlement agreement was made with the firm, which resulted in a financial penalty of over £24,000. And this is a case where we conducted an on-site investigation at the firm due to its involvement with a high-risk client. We found that the firm-wide risk assessment was not sufficient based on the size and nature of the firm. The form it was using to risk assess clients and matters did not adequately capture the AML risk. In some of the files we reviewed, it was also not being fully completed, suggesting a level of complacency among some fee earners. The firm did have strong PCPs and no major impact was identified on the files, save for some minor guidance on best practice. We issued a letter of advice here, and we would take a view that stronger enforcement action is likely should we identify similar failings in the future. So here are the four most common areas for referrals to us. Issues around client matter risk assessments was by far the largest area in the last reporting year. This was followed by policies, controls and procedures. Concerns around source of fund checks and firm-wide risk assessments were also common areas for referrals to us. So we will now look at each area in further detail, and starting with client and matter risk assessments. So the primary purpose of a client matter risk assessment is to determine the level of due diligence and ongoing monitoring that's needed based on the risks presented. Since 2019, we have seen a gradual increase in the number of referrals for investigation where the application of client matter risk assessments has been an issue or concern. We have found that some firms have no method of risk assessing clients and matters at all. so are unaware of the level of due diligence that's needed. Some firms have a method but are not stringently following this, which could lead to higher risk transactions falling through the cracks, and this is particularly in relation to conveyancing. Often firms provide us with a file opening form or something similar, which on the face of it might seem to capture a lot of information about the client and the matter, but it doesn't capture the AML risks in particular. And we also see client matter risk assessments that have been done several months into a business relationship. This is too late, and it could cause problems when funds are being accepted into the client account. So you must have a written process in your PCPs. Not only that, but you need to ensure that all relevant staff are aware of those processes, and any training that's provided should be recorded. Templates are useful, but this should not be considered as a tick box exercise, and do ensure that it is suitably tailored to your firm. Complete a client matter risk assessment at the beginning of each business relationship. If you are relying on information from a previous matter for that client, ensure it is available or cross-referenced on the current file. And this is particularly helpful for us in investigations and also our colleagues in the proactive supervision team when we are looking at files. Also, be prepared to revisit the client matter risk assessment if circumstances change throughout the course of that relationship. There's nothing to stop you altering the level of risk throughout a relationship as long as this is documented with the rationale. And as part of your obligations to monitor and manage compliance with your PCPs, I would recommend doing checks on client matter risk assessments to ensure that they are being completed adequately, and depending on the size and nature of your firm, an independent audit may be suitable. So now on to PCPs. These communicate to all relevant staff what they need to know about the practical application of the legal requirements. There has been an improvement in this area, and a lot of firms that we're seeing do now have written PCPs in place. We usually take enforcement action if we find that firms don't have written PCPs in place or if there are several areas missing. This is aggravated when we find the inadequacy of the PCPs has had an impact at file level, and we also consider enforcement action for historical breaches of the MLRs if the lack of compliance has stretched over a long period of time. So it is rare, but we are still seeing firms that don't have written PCPs in place at all. Some firms have them in place, but they are missing some of the mandatory criteria. And we've found that some common areas that are not covered are things such as reliance, reporting discrepancies to Companies House, and a firm's approach to each level of due diligence. And it's important to remember that even if something doesn't apply to your firm, it still needs to be covered in your PCPs. We also see firms that do have sufficient PCPs in place, but relevant staff aren't aware of them or are not correctly following them. There are some instances where staff are not monitoring compliance with the PCPs or have not obtained an independent audit. Independent audits are required depending on the size and nature of your firm, and they are a really useful tool to monitor the effectiveness of the PCPs that you have in place. So your PCPs must be documented in writing, kept under review, with each version saved for reference. They should also be subject to approval by higher management. Training must be provided to all relevant staff to ensure that they are aware of their obligations. Keep an eye on any changes to the regulations and things such as LSAG guidance, high-risk third country lists, all of which may inform your PCPs. Thank you, and I'm now going to hand over to Tracy to discuss source of funds.
Hey, thanks, Sarah. So what is source of funds? So a fundamental element of client due diligence is understanding the nature, background and circumstances of the client, including their financial position. So the source of funds refers to the origin of the funds that are being used to fund a transaction. So when you're undertaking work for somebody, you're not only asking where does the money come from, but also how and where did the client get the money for this transaction. So the need and extent of source of funds checks should be informed by your client and matter risk assessment, which is why it's so important to do that right at the start of a transaction. So a practice must scrutinise their transactions on a matter-by-matter basis with the objective of understanding the source of funds being used. Okay, and just to look at some of the issues that we're seeing, this is actually an increasing referral reason. So when the practice supervision team go out and have a look at the files, they will have a look at the client and matter risk assessment. They will also have a look at the source of funds work done on the file and the verification, etc. As a result, we are looking at we're doing a thematic review on it at the moment, and we will publish more information about this a little bit later on this year. So please keep an eye out for it. In terms of the issues that we commonly see, we see an overall lack of scrutiny. So situations, for example, where the figures don't add up. So, for example, there might be a residential purchase for £500,000. The fee earner has seen that £400,000 is coming from a bank account. They've done some source of funds work and established where £250,000 is coming from, but the £150,000 extra is in a black hole, so to speak, because no one knows where it's coming from, and that's obviously a red flag. So we also see scenarios where the matter might be high value or high risk and no information has been sought in relation to source of funds. We do understand that the regulations say that it's only where necessary, and so it's important to take a view on this. We are commonly seeing, as I say, high-risk matters where matters aren't being scrutinised adequately. We also see situations where fee earners may have obtained bank statements. They're on the file. The matter is listed as high risk on the client matter risk assessment, but then there is no analysis of where those funds are coming from. So the file effectively, for source of funds reasons, is incomplete. The final thing that we wanted to draw your attention to is third parties. Obviously, in the current economic environment, we're seeing an increasing amount of parents perhaps helping their children out with first purchases. And it's always important to do source of funds checks where there's an unknown third party involved, specifically where it's a high value transaction. So the tips and best practice, document absolutely everything. So when you've done your client and matter risk assessment, if you've decided that you need to do source of funds checks, make sure there's some analysis on the file and that you've noted and everything adds up. If you decided you don't want to do source of funds checks, just stick a note on the client and matter risk assessment. It should be low risk in that matter. And understand on each transaction when you need to do it. Keep an eye, as Sarah has said previously, on the high-risk third countries list. Think about politically exposed persons and any relatives and high-value transactions in particular. And keep an eye out, familiarise yourself with all of the red flags for money laundering that have been highlighted by the Financial Action Task Force. Okay. Moving on now to firm-wide risk assessments. So firm-wide risk assessments became a thing in 2017. Some people refer to them as a practice-wide risk assessment. Essentially, it's the same thing, and they are mandated under Regulation 18 of the Money Laundering Regulations. So each risk assessment should take into account the information that the SRA publishes and address the 5 key risk factors highlighted in Regulation 18. Just as a reminder, that is customers, countries or geographical areas in which you operate, products or services, the firm's transactions, and how your firm's products and services are delivered. So if you haven't identified the risks at firm level, it's going to be really difficult to get it right at client and matter level, because the firm-wide risk assessment forms the backbone of any anti-money laundering awareness and controls at the firm. And from your firm-wide risk assessment, your policies, controls and procedures should flow, your training should actually flow, and your customer due diligence obligations will flow from that document. So looking at some of the common issues that we see, I think it's probably worth saying up front that we do see less scenarios where there's no firm-wide risk assessment at all. We do see it occasionally. It's usually in the smaller firms, perhaps owner-managed, operated. More commonly, we see incidences where the firm-wide risk assessment is probably incomplete, so it doesn't either take account of the 5 key areas, or perhaps a template's been used and the template's been left blank, or it's not tailored to your firm and its clients. I've put proliferation financing on the slide here because as of the 1st of April 2023, you need to either have a reference to proliferation financing in your firm-wide risk assessment, or alternatively, you need to have a separate policy to cover it off. And the final point on Lexel accreditation really is about a couple of firms we've seen of late where they've got a Lexel accreditation, and so an auditor's come in, they've ticked a box to say that they have a firm-wide risk assessment, but then the firm is unable to produce that and show the SRA their written copy. So clearly in that situation, whilst it's fairly persuasive to suggest that they do have some sort of risk assessment, without seeing the written copy, the SRA would have to conclude that there wasn't one. So please just bear that in mind. In terms of tips and hints, I think as Sarah has highlighted previously, it needs to be in writing. Please keep it under review. So if you make changes, record it. Keep your old copies. By all means, use a template. We've got a great template on our website. It's very useful as long as you make sure that it's tailored to your firm and it's proportionate. And please do assess all risk areas, including proliferation financing. Before I hand over back to Lex, I just wanted to plug the SRA website a little, just to say that there is lots of information on there about money laundering, lots of guidance, as well as our warning notices. Also the templates, which can be incredibly useful. And if there's something that you're not quite sure about, obviously you can always contact the ethics team who will try and help you out. Or if you're having an inspection, by all means, speak to someone from the proactive team who will try their very best. So Lex, back over to you.
Thank you, Tracy. Thank you, Sarah. Some really great insights there, I think, into our enforcement work, and of course the useful hints and tips. Tracy, I keep thinking tips and hints. I'm not sure. We might have to go out to the audience and we'll get a vote in on that. We are going to move to questions through from our viewers. We've had a few come through already. I can see them appearing on the side of my screen here, so apologies if I look a little bit vacant as I'm trying to read out questions as we go. Please do, though, keep submitting those questions. Please do keep them coming in and we'll get through as many as we can. First question, though. So we talked about source of funds and source of wealth. What's the difference?
So the difference between the two, source of funds is a means of checking where the specific funds for that transaction has come from. For example, a salary, a gift, investments, whereas source of wealth is more of a holistic assessment of how the client has generally accumulated the wealth that they have. And you would normally expect to see source of wealth checks in higher risk matters, such as matters involving PEPs, or where a client is based in a high risk third country.
Thank you. Next question, and I have to say this one this one I sympathise with because it really confused me when I first arrived at the SRA. To a layperson, these two things sound the same. What is the difference between a letter of advice and a letter of guidance?
Okay, I'll take that one. So, a letter of guidance is effectively a closure. So it's perhaps where we see something where we feel that we can add a little bit of value by giving some sort of guidance, but we don't need the firm to do anything in particular. We're closing that matter down. A letter of advice is actually something that's recognised as a enforcement outcome under our RDPRs. So it's usually a scenario where we see a minor breach, but we don't feel that the breach is serious enough for us to give a financial penalty, for instance. But what we do want to do is perhaps ask the firm to change something or to do something different, or maybe tweak their policies or their risk assessments slightly. So I would add to that as well that what we do in investigations, when we get a matter, if the firm aren't quite compliant, we do try to help them to bring themselves fully into compliance. So it can be used for that kind of scenario.
Okay, thank you. Next question. This one's also from an anonymous source. To what extent can an onboarding or compliance team assist in AML and due diligence processes?
Thank you. So it's fine for these types of teams to do the front end customer due diligence, but it is important to remember that customer due diligence is not just a one-time exercise, it is an ongoing thing. So you could argue that the best person to conduct that is the person involved in the matter. Regulation 27, paragraphs 8 and 9 do require that you have to redo customer due diligence when circumstances change in a number of ways. So fee earners need to be equipped to deal with things down the line and meet their ongoing monitoring obligations. So you could question how you're going to know what's changed if a different team have conducted the customer due diligence. So I guess if you have got a team that's doing this, it's just important to have in place some really good communication channels between those people and the fee earner.
Okay, thank you. I've got a question here. This one is quite a long question, and this one is from Graham. Thank you, Graham. Is it likely the SRA will be increasing the amount of data collection from firms in order to implement a risk-based approach to supervision? And if so, what will your likely approach be to this? If firms do not have the requisite data, could this be subject to enforcement action? So I think I'll probably take that one actually, Graham. There's quite a lot there to unpick. First of all, I'm going to be unnecessarily sort of pedantic and say we have already implemented a risk-based approach to supervision. Please, we have an oversight regulator, so please don't tell OPAS that we haven't implemented a risk-based approach to supervision. They'll come and knocking on my door to say, Lex, what have you been up to? So we definitely already do that. However, are we going to increase the amount of data collection from firms? There's no proposal, I don't think, to increase the frequency with which we ask. So at the moment, we are considering just doing it annually, because and hopefully roughly the same time every year, because of course it allows people to operationally plan for a level of information that they then need to supply. In terms of the number of questions we might ask, or how much those questions might change year on year, the types of data we might collect, there may be times where we think actually we're going to remove this set of questions because it's not informing us in any meaningful way. It's not adding to our risk-based approach here. But equally, there might be times when we add in some new questions. However, every single time we add in or remove a question, you can absolutely count on the fact that we will have thought long and hard about what the question is. Is it accessible and understandable, or have we written it in sort of FRA specific jargon that means almost nothing to anyone else out there? And actually, what information are we going to gather off the back of that question? What difference will that make? What will we do with that information once received? So whilst I appreciate it's not going to be niche knowledge within your firm, we are never going to write out to you asking about your preferred brand of coffee in the office, because it's not going to make any kind of difference to our risk-based approach. If firms don't have the requisite data, could that be subject to enforcement action? Well, actually, that is already something we might occasionally have to take enforcement action on. So if firms do not respond to our data collection request, and we've seen that in years gone by, where we have had to make referrals through, but predominantly it tends to be that actually the vast majority of firms come back to us very quickly with the level of information, and we are hoping by making this much more streamlined and sort of operationally efficient for everyone, that it will be less onerous for them to do as well. I will say quick flag, quick plug. You will see more information on that in the SRA update newsletter that will be coming out, I think, this week. And the annual AML data collection exercise will start again towards the end of July. You can watch out for more on our website and on our LinkedIn feed as well. You'll see sort of reminders and public reminders coming out there as well. I have another question in here it's from a viewer. So I don't know who that viewer is. They're not named, but they are a viewer. Did you just say if you decide not to do source of funds, just put a note on the file? When and why would you decide not to do source of funds checks? So I suspect I might jump in and then refer to Sarah as more of a technical expert than me. But actually, that is not about you don't just decide not to do it, but you document that there is a very specific reason why you have decided that it is not appropriate to do source of funds checks in this instance. And I'm guessing, and Sarah can correct me if I'm wrong, that might be something like because we've done X amount of business for this client already, and actually you can find all the documentation on source of funds in another file, and it's over here, for example. But Sarah, correct me if I'm wrong.
Yeah, so the way that we interpret the regulations is that you are required to apply a risk-based approach, meaning the firm, client and matter risk assessment does need to be covered to be considered when deciding if it is necessary to do source of funds. And then, like Lex has advised, if you do decide that it's not necessary, we would expect to see full rationale on your client matter risk assessment on somewhere on the file to explain why you decided not to do it in these circumstances. And again, if you are scrutinising source of funds and you've decided that the source of funds checks are adequate, just an explanation as to what you've done and how you've come to the conclusion that everything was okay to proceed.
Thank you. We have another question here. Tracy, this one might be for you, actually. You've said there's an increase in regulatory settlement agreements. Can you explain why this is?
Yeah, it's so previously we focused on notices, so a very long document, and that effectively goes to our adjudication panel or to an adjudicator singular, as and when representations come in from a firm. So quite a prolonged period of time elapses when that happens. So the regulatory settlement agreement is something that we've used more often, and it is effectively it's a quick way if the firm agrees that there may have been an AML breach, and if they are willing to accept the financial penalty that we suggest as an outcome, then it's something that we'll go with as a way to effectively bring that matter to a close in quite a quick and a speedy fashion. So the idea is it's not really a quicker thing for us, it's for the customer. So an awful lot of the feedback that we get is that firms and individuals find it stressful to deal with an investigation scenario, and we understand that the regulatory settlement is a means to actually come to an outcome quickly and to move the matter through.
Thank you. I have to say, I do like that. I will never, of course, apologise for the fact that periodically we will need to investigate things, and I completely understand that might be stressful. But for me, like one of the best ways of delivering great customer service to everyone impacted would just be around the fact that we give them an answer as quickly as possible, and it is as reasoned and sort of understandable as possible. And I think, yeah, the regulatory settlement agreement feels like a good way for everyone to be able to still have that engagement with their regulator and supervisor, but nevertheless move that process on reasonably quickly. So that makes sense to me. Questions are coming in thick and fast, and I'm absolutely going to lose track. Sarah, I think this one's probably for you, actually. It's a question in from Brian. Thank you, Brian. Is the SRA's position on the independent audit function still that only sole practitioners don't need this and that all other firms do?
The short answer to that one, Brian, is no. We do take a slightly different approach when it comes to independent audits. The only time that we've really reported on this was back in 2019, 2020, when we made a statement that we would expect independent audits are required if a firm has more than one office or has fee earners who focus on an area of regulated work, such as conveyancing, or if the partners are being responsible for other compliance with the regulations. So it's not necessarily that it's just registered sole practices that are ruled out. It's a number of different firms that we would expect to see independent audits from.
Thank you, Sarah. There's another question here, actually, and again, this one's not from a named individual. What if different investigators have different approaches to the same issue? What is the SRA doing to ensure there is a consistent approach? I mean, I think that's a fair challenge, and certainly one that will get levied at any number of different kind of regulators in this space. I will say, since joining the SRA, I've actually been really, really impressed with the amount of work that goes into making sure that decisions are consistent and that investigation processes and procedures are consistent as well. As you would expect, there is an astonishing amount of focus on things like quality assurance checks done behind the scenes. But there's also very much a culture of sort of proper case discussion. So really understanding, so what questions have we asked? What information have we sought? What is the picture that we are seeing here? You know, what is it we are finding from the firm? What evidence have we seen actually to support the conclusions that we think we are drawing here? So whilst some of the questions might come out to you in a different way, you know, people might choose emails, letters, phone calls, etc., to obtain that information. Ultimately, they're still driving through to try and understand the answer. You know, they just need to understand what has happened here, and to make sure that we've got consistency in that place.
Can I add to that? Sorry, sorry, Lex, to interrupt. The other thing that we do internally is we keep actually a record of all of the outcomes. So it's almost like a precedent document, so that we can keep track of combinations of things, so potential AML breaches, so that we actually reach the same outcomes in different, like sort of the same scenario, if that makes sense. So if somebody's not got tailored PCPs, it ensures that if firm B also has the same issue 6 months later, we'll be able to refer back to that precedent document and we will form the same outcome, if that makes any sense.
I think it does. Thank you very much. All right, let's just have a quick look. I've managed to go out of order on my list of questions, which is now going to confuse me utterly. Here we go. So I have a question in from Matt. How much focus is there on carrying out enhanced due diligence where a client flags as potentially a sanctioned individual or a linked business? How far do we need to go on adverse media checks? So neither Sarah nor Tracy want to jump at that one, I see. Okay, so look, I think from my perspective, what you were trying to do here is you're trying to mitigate risk, right? You are trying to understand what is the risk that this client potentially poses to you, your firm, your business, but you also want to understand the risk that individual might pose in terms of money laundering. So I think there you go as far as you need to go, and I appreciate this is a how long is a piece of string answer, and I apologize for that. But you need to get a full understanding of that picture of that person. So what is this telling you? Actually, does it all stack up? Does it all make sense? Have you asked all the right questions? And I think if you cannot tell yourself hand on heart that you have asked all the right questions, you are very happy with the answers that you've got, and it does all make sense, then, and I think if you cannot do those things, then you probably think this is not the client for me. There may be another firm out there with a different risk profile who is happy to engage doing work with this individual or this firm, but it's probably not one for me. I know it's a bit wishy-washy, isn't it, in terms of how far do you go? But actually, I think the answer is to build a really clear picture for yourself. That's how far you need to go.
Yeah, I agree with that. And We do have some fantastic colleagues within investigations and proactive that have far much more knowledge on sanctions than us, I'm afraid. But the question just says a potential sanctioned individual. So I think you need to go as far as you can with the due diligence to determine whether they are sanctioned or not. I think that's all I have to add there. So thank you.
Thank you. Another question then. Again, this one's in from an anonymous source. So using AI or technology for onboarding or checks, can we use it? Is it a good idea? I might take that one as well myself, actually, just because I'm mindful that for those of you watching this live or perhaps only a day or two after this, there's been quite a lot in the news this morning about the possibility that a barrister used ChatGPT to create or unexpectedly and inadvertently perhaps used ChatGPT, which provided some fake citations to be used in a court case. So, you think with every step forward that you get with things like AI, there is potentially a step back as well. My general view, I love anything that makes my job easier, right? That makes my job easier, more efficient, especially where it's things that I think probably don't need a huge amount of mental space from me. So I'm not against technology, and I'm absolutely not against using tools that will make your life more straightforward. The one thing I would say though is whether you are creating a bespoke product for yourself, you've got some tech wizards who are going to go and create this tool for you, or whether you're buying an off-the-shelf product, I think you absolutely need to understand the limitations of that product. I think you need to understand that once that product has been developed and is available, there will then be people out there who are seeking ways to circumnavigate that product and find the loopholes, etc. So the ownership, the responsibility of that due diligence still sits with you. It does not sit with a product that you have bought, paid for, developed, whatever, and you need to bear that in mind. I don't know why I just jumped on my soapbox with that, didn't I? So sorry. I felt like I was delivering a firm lecture. Okay, I'm conscious that we may be coming into the last few questions now. What else we got? So where cases are closed, and Tracy, I think you referred to a figure of about 70% earlier, but where cases are closed with no enforcement action taken, are there any common themes appearing where we think they've correctly been referred for investigation, but then the result of those investigations that there isn't enough to take action? Are there any themes we're seeing coming out of that?
I think it's a variety of reasons, really. When the AML proactive supervision go out on site or collect information as part of a desk-based review, sometimes firms just simply forget to send in the right documentation, or perhaps they need to go away and find it from storage or from some sort of filing cabinet. So occasionally we just haven't got the correct information to be able to make a snap decision at referral point, and that becomes clearer further down the line. Alternatively, we can look at a situation and the breach is so minor to be virtually non-existent, and so it's usually something that we can close down without the worry that the firm isn't lacking in compliance at all. So I would say that there's no hard and fast rule, but generally it's because of the information not coming to us at referral point or it being insignificant in terms of a breach.
Okay, thank you. And then one more question coming through: how much of an issue, is inadequate supervision or training of fee earners when it comes to investigations? Well, just a quick plug for our website again, because of course the AML Directorate did their thematic into the subject of training last year, and we presented that at last year's compliance conference. So do have a quick look on our website, and you can read through the conclusions that we drew in that training thematic. I guess in terms of training of fee earners and senior staff within any kind of firm, I would say that is absolutely vital, right? So there were two things that the training will provide you with. One is actually records, so that you can prove to the SRA that you've provided the right level, the right quantity, the right quality of training to your staff. But the second thing, of course, is that actually if your staff are properly trained, and aware of the risks and what they are doing, then you are playing your part in making sure that actually the UK and your law firm in particular remains a really hostile place for those who want to launder money, who want to commit economic crime, and that feels like a really good thing. So it's two wins there for you. If you don't train your staff properly and effectively, and your firm does end up being used to launder money, you've got potential financial sanctions against you, but you've also got the very real reputational damage that's done as a result as well. If you do have a look at the training thematic, again, shamelessly plugging this one, but there are so many hints and tips in there as well around ways to kind of bring that training to life, to make it more engaging, more accessible. It doesn't have to be a very sort of staid, classroom-based environment. You can try and make it fun. You can try and make it light touch, whatever it is you need to do to just make sure you bring that subject matter to life for your people. That is really important. Another question here. If money came from abroad through a bank, reliance can be made on the satisfaction of the bank for that transaction. Sarah, did you want to take that one?
Yeah, so if I was looking at a file, I would expect to see that the firm has done its own source of funds checks, regardless of whether it's come through a bank from abroad. The responsibility is still yours. You are still obliged to apply the regulations when looking at source of funds. So the LSAG guidance also advises that the responsibility is still yours, basically. So you can't place reliance on matters like that.
Okay. Thank you, Sarah. I think we were all hoping for yes, of course, that would be fine, but sadly, it doesn't sound like that. I think that probably does bring us to the end. I'm getting all sorts of messages now from our tech support teams going, no, you're going to run out of time. You need to stop. Can I just say thank you once again, Tracy and Sarah, for your time, and a big thank you to everyone in the audience for joining us today. Thank you to everyone who put through your questions as well. You've definitely made it more interesting and more engaging, I think, for all of us as a result. I am conscious we covered quite a lot in this session, so I'll repeat what Tracy said earlier. If you do want more information or to look at any of the SRA guidance we mentioned, all the links to the resources will be included on our website, and you can go to the events on demand page. You can also watch this session again, share it with colleagues, etc. We would, of course, also like to hear your feedback, so do let us know what you thought by clicking on the feedback link in the video description. It will only take a minute, I promise. It's not a 50-page questionnaire, and it'll definitely help us improve what we do. Additionally, if you do have any suggestions for future webinars, or you would like to join us on a webinar, if you fancy being a star, at least within the relatively limited confines of the SRA and the legal profession, then please do pop your contact details in there as well, and we will see about reaching out to make contact with you. Another shameless plug, I'm full of them today. We have another AML webinar. It's happening right at the end of May, taking you smoothly into the bank holiday. What more could you ask for? And that will be a webinar focused specifically on sole practitioners. You can sign up for that one on our website as well. Very briefly, because I've just gabbled all of that at you, thank you so much for watching. Do not forget this webinar will be available today to watch on demand, and all of the links to the resources will also be available at sra.org.uk. Thank you again.